Hello friends, in the series on the income tax cases, today we will discuss a matter which is a perfect example that how mechanically and arbitrarily the CPC is rejecting the very legitimate claims of the assessees in various matters. In such type of matters, it has been seen that the CPC is rejecting the claims of the assessee which the assessee ought to get as per law. In the present case, the CPC denied the exemption of the assessee under section 11 on the ground that the assessee has not filed form 10B along with the return of income. As per the pursual of section 139 read with section 11, there is no law that the assessee has to file form 10B, that is the audit report by the chartered accountant along with the return of income. The law is that the form 10B is to be filed before the due date of filing the return of income under section 139 subsection 1. So in case the assessee first file its return of income and on the next day, but within the due date of filing the return of income under section 139 subsection 1, if the assessee files form 10B, so whether on this ground the CPC can reject the claim of exemption under section 11 subsection 2 of the assessee. This issue has been taken by Ahmedabad ITAT D bench in the case of Deputy Commissioner of Income Tax Exemption versus Gujarat State Board of School Textbook, which has been reported in 113 ITR Tribunal Short Notes 33, and the date of the judgment is 1st July 2024. In the present case, the facts are very simple. The assessee filed its return of income on 29th November 2014. And on the next day, the assessee filed form 10B on 30th November 2014. Both the income tax return and form 10B was well within the due date of filing the return of income under section 139 subsection 1. But when this return was processed, the claim of the assessee under section 11 was denied just on the ground that the form 10B has not been filed with the return of income, so the assessee is not eligible to exemption under section 11. The mandate of section 139 is that the form 10B is to be filed before the due date of filing of the return of income, but the mandate is not like that it is to be filed with the return of income. The assessee may file the return of income and then afterward it can file form 10B, but if the form 10B is filed before the due date of filing of the return of the income, the exemption cannot be denied. In the present case, the CPC denied the exemption, then CIT appeal allowed the exemption, and the ITAT also upheld the order of the CIT appeal giving the exemption to the assessee under section 11. In a number of the cases, the courts have allowed the exemption under section 11 even if the form 10B has been filed before the processing of the return under section 143 subsection 1, and even in the remote cases when the assessee failed to file the form 10B and when the assessment proceedings were going on, if the assessee filed the form 10B even during the assessment proceedings, the courts are allowing that on the basis that this is a procedural requirement, and if the assessee complies with that procedural requirement even during the assessment proceedings, the exemption under section 11 cannot be denied on the ground that it is not filed within the due time. So friends, in the present case, the denial of the exemption by the CPC is a perfect example of culpable exercise of power and mechanical use of powers by the computer system of the Revenue Department. At the end of this video, Once again, I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax Exemptions versus Gujarat State Board of School Textbook. And this case has been reported in 113 ITR Tribunal, short notes 33, and the matter has been decided by Ahmedabad ITAT D bench, and the date of the judgment is 1st July 2024. Thank you, friends.